Kathy Jafari, and I have the privilege of serving as your chancellor this year. I say, thank you. Thank you. I say it's a privilege because we've spent a lot of time working on a lot of stuff this year, and I see all of the faces in the room with whom we have done that. And that's been the privilege. It's been working with you. So I want to thank each and every one of you for being here, for bearing with the heat, and joining us tonight. We promise to keep trying to make this as cool as possible. This is a beautiful space. Each time I turn and I see Independence Hall, and then if you're outside, you see the Constitution Center, how much better can you get being in a space like this in terms of history? In terms of the heat, we never could have imagined that we would be in this extreme heat wave. But again, it's wonderful to be at the Independence Visitor Center. I actually want to say we are here tonight to celebrate. We are here tonight to celebrate so much, from the 60th anniversary of the Voting Rights Act to our incredible Executive Director, Harvey Hurdle, who is retiring tonight, in a couple of days. So let me first begin. Shout out to Lou Ruley, who actually helped launch this idea, and to our dear friends, the Committee of 70, especially CEO Lauren Christella, President and CEO of Committee of 70. Lauren, please stand. And Tanisha Bezu, Program Director at 70, for helping us with this program. Tanisha, please stand. Thank you. Tonight's program is perfect timing for the Bar Association, as this year was our inaugural year that the Bar Association hosted a group of members for an unforgettable and, for many, life-changing experience, a civil rights journey. We had the unique opportunity to travel from Atlanta to Montgomery to Selma to Birmingham, learning about the civil rights movement in 1965. We were mesmerized by the fight for justice and equal voting rights, learning from the people who witnessed and made history. A shout out to Blank Rome and Kathy Ockrock for all of her hard work. Without them, we would not have had a civil rights journey. Through our program tonight, we hope to bring the spirit of that journey here, a block away from the site of our nation's founding. We want to continue the conversation about voting access and voting rights that remains just as crucial to our future as a nation as it was 60 years ago. And the conversation does not end here tonight. Tomorrow, I am proud to share with you that beginning at 9 a.m., we are continuing our Meeting the Moment series with a fully virtual program, so you can stay in your nice, cool homes, featuring an introduction by ABA President Bill Bay, a keynote address by Judge McKee, and a panel of distinguished judges and attorneys discussing efforts to protect the rule of law and defend our democracy. Moreover, we do not have enough time this evening to present all that we want to present by our phenomenal panel that you will hear after our keynote speaker. And so what we have been able to establish with Tara Phoenix is a CLE program in August. So save that, you'll hear about the date coming up so that we can continue the conversation of protecting voting rights and celebrating the Voting Rights Act. Also, I am so excited to share, thanks to the working with our Chancellor-elect, Ezra Wergelernter, we will be hosting our second Civil Rights Journey, and I actually have the dates for 2026, May 14th to the 17th, so please keep your eye out if you want to be part of one of those life-changing experiences. Tonight's program and all the efforts are only made possible through the support of our members, all of you for being here tonight, so thank you, our sponsors, and our program partners, whom I'd like to thank now. I already mentioned the Committee of 70, but I will do so again. We thank you for your support and your tireless work on behalf of our city. We are proud to be in partner with you for both efforts. Our firm's sponsors, Blank Rome, Cozen O'Connor, and Feldman, Shepard, Wergerlernter, Tanner, Weinstock, and Dodded at the gold level, Fox Rothschild at the silver level, and Fogoletti Law at the bronze level. Without these sponsorships, we are not able to do these programs. So I have to tell you how meaningful they are. Our annual partners, Alavista Legal Search, Bit by Bit, My Benefit Advisor, U.S. Affinity, Practice Made Perfect, and Wealth Enhancement, many of whom are here tonight. Thank you for joining us. Please say hello to our sponsors during the reception. And our institutional partners, Drexel University and Temple University School of Laws, the Philadelphia District Attorney's Office, and the City Law Department. The Defender Association of Philadelphia, Community Legal Services, Philadelphia Legal Assistance, the Public Interest Law Center, Senior Law Center, and the Support Center for Child Advocates. I'm excited that it's that long of a list, so thank you for bearing with that list. It's very important to us to have these institutional sponsors. And now to some wonderful pieces of our event tonight before our substantive program. I am pleased to introduce the LGBTQ+ Rights Committee co-chair, Crystal Kane, who will present the 2024 Cheryl Ingram Advocate for Justice Award. I'd like to thank both Crystal as well as our other co-chair, Maureen Holland, who wasn't able to be here tonight, for their work overseeing this award. Crystal, please.
Thanks so much, Kathy. Hi, everyone. I'm Crystal Kane. I'm the pro bono attorney at Blank Rome and one of the co-chairs of the LGBT Rights Committee. I want to start by saying Happy Pride. It's still Pride Month for another few days. So I'm so happy to be able to present the Cheryl Ingram Advocate for Justice Award. Every year, the LGBT Rights Committee gives this an award to an individual who made substantial contributions to the LGBTQ community here in Philly. In honor of Cheryl Ingram. Cheryl served as the Director of Policy Administration for the Philly Bar Association, and she was a member of the board of Gallup, which you now know as the Philadelphia LGBTQ Bar Association. What makes this year so special is that we have not one, but two amazing Cheryl Ingram Award winners. Our first honoree, Victoria Sorois, she founded Asylum Pride House, a nonprofit organization that provides housing and other vital resources to members of the LGBTQ community who've come here to Philly to seek asylum. In 2022, while still working her full-time job, she founded Asylum Pride House. The program offers housing, resource navigation, wraparound services, and a community for people, specifically for members of the LGBTQIA community. To quote the nomination letter, Asylum Pride House has supported clients from across the globe: China, Colombia, Guinea, Honduras, Jamaica, Sierra Leone, Nigeria, Kuwait, and Venezuela in 3 years, creating a powerful community bound together by shared resilience and identity. And our next honoree, Megan Watson, is an attorney at BKW Family Law who spent years representing a non-biological parent who wanted to meet her child. Megan's client and her wife utilized assisted reproductive technology to have a baby. There were 2 women. During the pregnancy in which her client's wife carried the baby, the relationship dissolved and they divorced, and her spouse decided that she would not allow Megan's client to meet the child. Megan spent years representing this client. I'm going to be brief because this is a really big case, but I'll just say that Megan advocated for her client all the way to the Supreme Court and established law. Thanks to Megan, we now have intent-based parentage in the state of Pennsylvania as of March 20th. Yeah. So, because of Megan's advocacy, queer families have another path to family stability. Yeah, these are two awesome women, and I'm going to call them up both to accept their awards.
Hi, everybody. Thank you so much, Crystal, for the loving words. As you can tell, I'm getting over a really fun summer cold that sneaks up on you every so often. So I apologize if I cut out or if I need to cough. But I have my trusty water. So, as a founder and director of a still young nonprofit organization, being recognized by the Philadelphia Bar Association and receiving the Cheryl Ingram Award is such an honor. Over the past years, I've had an amazing network of individuals who've given me endless support and guidance. Asylum Pride House would not have been able to house 12 individuals and support countless more with wraparound services in the first year and a half of our program's existence without the help of so many folks. And so I'd just like to thank a few individuals. The Sisters of St. Joseph Newcomer Housing Alliance, specifically Sister Eileen McNally, who believed in me and our mission from the moment that I walked in St. Helena's convent doors, has continued to be a fierce advocate, especially during this time of us exploring our program's growth. And I want to thank as well all of our board members for their openness to learn with me as I embark on this journey, because I had no idea what I was doing when I started. But we're doing wonderful things now, and I'm so grateful. And then also a special thank you to our case manager, Louisa, as well as one of our board members, Ray, who nominated me for this award, and I was so shocked and so grateful. And then also just a very special thank you to my girlfriend, who is my rock, and more often than I would like to admit, is also a free physician for me to run potential client injuries by. It's always wonderful. And then I want to really take a special moment to say thank you to everybody in this room who is an LGBTQ plus attorney or ally, who has in the past taken pro bono immigration cases for LGBTQ plus individuals, specifically immigrants. I get to see in action how transformative receiving, accepting, and affirming legal services is for our clients, and it can truly have life-altering effects. And so this work can be really hard, especially in these times, we all know, but my clients and myself commend you for this work that you do to support those who had to flee and seek safety just for loving who they love and for being who they are. It's just an integral part, and you're an integral part of the community that supports these individuals here in Philadelphia. So I really want to say thank you so much. Thank you.
Good evening. I am deeply honored to stand before you tonight as the recipient of the Cheryl Ingram Advocacy Award. To be recognized in Cheryl's name, a tireless advocate for the LGBTQ community, is really a humbling privilege. This award is not about me alone. It's about the courage of my client through the nearly 3 years of litigation it took us for their parentage to be confirmed, proof of their strength and dedication, as well as their love as a mother. It's also about the team and community of people who surrounded me and helped me through this process. I thank my partner, Lisa Shapson, for agreeing to handle the appeal pro bono, and to my wonderful staff, who I could not have done this work without. To Jackie DiColo for being there from the beginning, for Helen Casal and Lee Carpenter for their work on the amici briefs and providing critique during my oral argument prep. For Mark Momgen and the Bar Association in joining the amici. I also want to thank Judge Palmer, whose prior advocacy is what paved the way for the Supreme Court's adoption of parentage by intent. The courtroom is not always a friendly place for those who live outside the boxes that society and the law tries to draw around them. But it is our responsibility as attorneys, as advocates, as people, to think outside the box and break down those walls. As we sit here, though, the walls that advocates have fought so hard to break down are slowly being erected again. This is a concerning time when hard-won rights have been and are being threatened to be taken away. Our advocacy does not always need to be loud, but I believe it must be unwavering. Visibility, dignity, and legal protection for the LGBTQ+ community must never be conditional. So keep fighting the good fight. I know I will. Thank you.
Congratulations, Megan and Victoria. We are honored to recognize your amazing work. Again, round of applause for Megan and Victoria. Each year, the Philadelphia Bar Association recognizes law students who have done outstanding pro bono work during their time in law school. How amazing is the Summer Quarterly to be able to honor law students, the future of our profession? This award is named for Eve Biskind Klothen, who headed the Rutgers Law School pro bono program for 11 years. A graduate of Vanderbilt Law School and the University of Michigan, Eve served as a federal agency fraud litigator in Washington and was the founding director of the Philadelphia Volunteers for the Indigent program, now Philly VIP. She has been active in the Philadelphia Bar Association and its foundation for decades. Eve was motivated by the fact that while lawyers are provided in criminal cases, there is no right to counsel in most civil cases, and yet defendants in civil cases often cannot afford legal counsel, which leaves a desperate need for pro bono support. As Eve said, a lot is at stake in those civil cases. You can be thrown out of your home, you can lose your child, you can lose your job. There is no meaningful access to justice without access to counsel. So to all the lawyers in the room who provide pro bono service, we thank you for your work. Eve changed the culture at Rutgers and more broadly at law schools in the Delaware Valley. She transmitted the pro bono ethic to a generation of law students by greeting students at the door and saying, "Get ready, roll up your sleeves, there's a lot that needs to be done." The Bar Association named this award for Eve upon her retirement in 2012, and those of you receiving the honor should be deeply proud to receive it in her name. Many of this year's recipients are with us tonight, so we're so glad you're here. As I read your names, I'm going to actually ask that you please stand to be recognized for the audience. Please hold your applause until all names have been read, and then we can give a resounding applause for all. From Drexel University Thomas R. Klein School of Law, Emily Barkin, Riley Blozon, Victoria Carvello Salas, forgive me if I'm mispronouncing names. Did I do okay? And you can correct me from the audience. Okay, I love those smiles. Stay standing. From Rutgers Law School, Lori Bartolomea, Jabri Douglas, Jasmine A. Montgomery, and I know it's hard to hold applause, but it's great because you get to hear people's names. From Temple University, James E. Beasley School of Law, Geneva Lamont, Alex Leon Gregory, Dan Simons, love seeing the smiling faces. From the University of Pennsylvania Carey School of Law, Alejandro Ashworth, Carrie Chapman, Levi Phillips. From Villanova University Charles Widener School of Law, Nicholas Nick Johnson, Sydney Sanders, Andrea Solis Canto. And finally, from the Widener Delaware Law School, Christina Kass, Luke Clinton Dees, see them in the back, and Angelica Richardson. And now the audience may applaud for these wonderful, woo! Congratulations, and thank you so much for being here tonight. And we look forward to your engaged involvement with the Philadelphia Bar Association, and hint, hint, Committee of 70 in the future. So, with that said, I have the wonderful opportunity now to move to the programming part of our event tonight. During the association's civil rights journey in March, our group had the emotional privilege of walking across the Edmund Pettus Bridge in Selma, Alabama, following in the footsteps of civil rights activists who exactly 60 years earlier, in 1965, set out to march from Selma to Montgomery to demonstrate against racist and segregationist barriers designed to keep Black Americans from voting. Images of the brutal attack on the marchers were broadcast around the country and helped lead to one of the most significant pieces of legislation of the civil rights era, the Voting Rights Act of 1965. The act provides nationwide protections for voting, aiming to give Black and brown communities equal participation in our political system. As legal professionals, we have sworn to be the guardians of the rule of law and tireless advocates for access to justice. At the Philadelphia Bar Association, we have always viewed voting as an access to justice issue. Voting provides us the ability to voice our opinions on the laws and the policies that govern this country and to hold our elected officials accountable to the expectations we have of them. And in today's environment, this is critical. We are honored to have an esteemed keynote speaker here tonight to discuss voting rights in America. Professor Akhil Reed Amar is the Sterling Professor of Law and Political Science at Yale University, a constitutional law scholar and author of several books, including Born Equal, Remaking America's Constitution, 1840 to 1920, which will be published on September 16th, so be sure to get your advance copy, and information will be forthwith from the Bar Association. After graduating from Yale College summa cum laude and from Yale Law School and clerking for Judge, later Justice Stephen Breyer, Professor Amar joined the Yale faculty in 1985 at the age of 26. He is Yale's only living professor to have won the university's unofficial Triple Crown, the Sterling Chair of Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. He, of course, is a renowned scholar and professor and has won countless awards. But I do have to say, Professor, I was absolutely intrigued by the fact that you were an informal consultant to the popular show, The West Wing. Professor Amar, thank you for accepting our invitation to speak with us this evening. Everyone, please welcome Professor Amar to the podium.
Well, Thank you so much for that kind introduction and for this kind invitation. As I look out, I see some friends in the audience, some old friends from college, and now it's old friends because we're getting old. But this is a kind of emotional moment for me because I've been doing constitutional law for many decades, and I think I decided I wanted to do this when my parents brought me to Philadelphia when I was 11 years old, and they brought me there, and I decided that's what I want to do. And my mom took me around the city. We walked hand in hand. My dad went to meetings. She passed away 3 years ago this week, and I'm thinking about her right now. I'm going to tell you the prehistory of the Voting Rights Act of 1965. And I'm going to share with you some sections from this book that's not out yet. I've never actually previewed this passage before, and I'd love to share it with you here. So the first thing you might wonder is, well, why didn't the document that was drafted over there have the phrase right to vote? Because it didn't. And there are two documents, the Declaration and the Constitution, and neither quite says the right to vote. And the honest answer is it couldn't because of race and slavery. And the South would never have gone along to agree to a constitution that affirmed a robust right to vote. Now the story that I'm about to share with you begins. It begins because there's a civil war, and Abraham Lincoln and the Union win that civil war, and that changes everything. Those who fight for the Republic should have a right to vote in the Republic. So thought the ancient Athenians. So thought the ancient Romans. So thought America's leading founders. And so thought Abraham Lincoln. All free adult male resident citizens could vote in ancient Athens. Ditto for the later Roman Republic. In each place, the same core group bore arms in defense of the city. Behind closed doors at Philadelphia in the summer of 1787, Benjamin Franklin championed this classical Republican theory and practice, strongly and successfully opposing elitist proposals to insert to the Constitution federal property qualifications for voting. So there are no federal rules, but states actually, because of slavery and race, had all sorts of power to do whatever they wanted. Section 2, and then comes the Civil War. Section 2 of the 14th Amendment, which actually has the words right to vote in it, first time, should be read against this classical Republican backdrop. The amendment's definition of those with a presumptive right to vote, all free adult male resident citizens, closely tracked the Republican practice and theory going back thousands of years. But instead of guaranteeing this right to vote, Section 2 merely forced disfranchising states to lose federal seats proportionate to the scope of disfranchisement. In the North, this Section 2 penalty would, by design, be negligible in most places, including here in Pennsylvania, because the disfranchisements only barred free black adult male resident citizens, a tiny percentage outside the border states. At war's end, then, blacks who had borne arms for the Union, including blacks who had lost limbs for the Union, in most places had no absolute right to vote, even in Union elections or in state or local elections for that matter. Abraham Lincoln thought this was wrong. He publicly said so. What Americans after Ford's Theater came to appreciate were his last words to his fellow citizens. Indeed, Abe quite literally died for his public defense of black suffrage for black soldiers. By the way, how many of you knew that? Okay, good. That most of you don't, so that means you're going to have to read the book. Back on the prairie, in his 1858 debates with Stephen Douglas, Abe had taken a different position. Quote, "I am not, nor ever have been, in favor of making voters or jurors of Negroes, nor of qualifying them to hold office," unquote. He declared in his fourth debate at Charleston, Illinois, echoing comments he had made in earlier debates and would repeat ad nauseum in later debates. Then the war came. In that war, black soldiers fought for the Union, lost limbs for the Union, and died for the Union. Black soldiers did so in massive numbers, and they did so at Abe's express and repeated urging. Abe then changed his mind about black suffrage. He first expressed himself privately to trusted confidants. Sometime in December 1863 or early 1864, he unbosomed himself to General James Wadsworth. This is a private letter that he sends. I cannot see, if universal amnesty is granted to white Confederates, how under the circumstances I can avoid exacting in return universal suffrage, or at least suffrage on the basis of intelligence and military service. I regard it as a religious duty, as the nation's guardian of these people who so heroically vindicated their manhood on the battlefield, where in assisting to save the life of the Republic, they have demonstrated in blood their right to the ballot. The restoration of the rebel states to the Union must rest upon the principle of civil and political equality of both races, and it must be sealed by a general amnesty. In mid-March 1864, Lincoln quietly began to nudge his allies to swing into action. In a letter to Michael Hahn, the recently elected governor of the Union-backed regime now occupying Louisiana, Lincoln wrote as follows: "You are about to have a convention, which, among other things, will probably define the elective franchise. I barely suggest for your private consideration whether some of the colored people may not be let in, as, for example, the very intelligent, and especially those who have fought gallantly in our ranks. They would probably help, in some trying time to come, to keep the jewel of liberty within the family of freedom. But this is only a suggestion, not to the public, but to you alone." So this is what we call a trial balloon. He's floating it, he's moving toward it, he knows where he wants to go, but he's got to time things. These things must be done delicately. After Appomattox and the fall of Richmond, Lincoln was at last ready to go public with his new vision. In formal remarks delivered on the White House lawn on April 11th, this would be 1865, Abe declared that, quote, "I would myself prefer that the right to vote were now conferred upon the very intelligent and those who serve our cause as soldiers." Unquote. He would have gone further than this. This is just his first, toe in the water. Countless Americans near and far experienced Abe's exposition via newspapers. John Wilkes Booth heard these remarks in person. The instant he heard Abe endorse black suffrage, he turned to his co-plotter, David Harold, and growled, "This means," N-word, "citizenship. Now, by God, I'll put him through." 3 days later, Booth did just that. Not long after Lincoln's last speech, the brilliant artist Thomas Nast put forth a similar vision in Harper's Weekly. In Nast's grand tableau, America's allegorical goddess, Lady Columbia, positions herself on her throne of justice, I think you mentioned the word justice, and ponders the fate of both former rebels and colored heroes. If a man such as Robert E. Lee, depicted as kneeling in submission, deserves a pardon and restoration of rights, doesn't an ever-loyal black veteran who has risked his life and literally lost his right leg for the Union deserve the franchise? Shall I trust these men, ex-traitors on the left, Columbia wonders, and not this man, a crippled colored Union soldier on the right? So I'd like you to look at that. That's okay. It was a brilliant argument, matched by brilliant artwork. Shall I trust these men, traitors, and not this man, who's lost his limb for the Union? The stoic and one-legged soldier tugs at the heart. Nast embellishes this big argument, splashed across a massive 2-page spread, 18 by 24 inches, with spectacular, almost subliminal details made possible by new printing tools and techniques. The black soldier's buckle cleverly matches Lady Columbia's brooch. Both represents us, U.S., the U.S. The names of battlefields, especially linked to black valor, hide in the folds of war-shredded Union battle flags. So So that's what those images are. And they're from the book, of course. I'm sorry that my Xerox machine was not so good, but they look better in the book. Brilliant, beautiful, logical, principled, and poignant arguments do not always carry the day, even in a great democracy. Slavery had always been wrong, but America ended it decisively only because of a ghastly war. Racial equality was always right, but America's Constitution enshrined this idea, first for civil rights and then for political rights, only because most Southern whites in the mid and late 1860s were temporarily on probation, excluded from Congress until they proved their proper Republican bona fides. In 1866, Abe's allies in Congress did not fully redeem the vision of his last speech because they did not have the votes. Northern white voters back home in 1866 were not ready to eliminate race discriminatory voting rules that prevailed in all but a few northern states. Had congressional Republicans that year proposed a 14th Amendment flatly banning all race discrimination, civil or political, the amendment would have probably failed, and the party would likely have lost otherwise winnable seats in the 1866 election. So Republicans held back. Abe surely would have understood. He was a gifted politician, the best of his era and probably the best of the century. As a proudly Republican, small r, politician, he strongly felt the need to listen to voters, to win winnable elections, to bend history's arc toward justice only so much as it could in fact be bent at any given moment, and then to bend it more in future days as soon as events allowed. In this spirit, Abe's spirit, his congressional allies waited until February 1869 to propose a proper amendment, the 15th, flatly prohibiting race discrimination in voting and indeed in political rights more generally, including jury service, military service, and office holding. Over the ensuing 12 months, enough states said yes, often in highly partisan state legislative votes, to suffice, thus completing a Reconstruction triad of equal freedom rights, 13th Amendment, equal civil rights, 14th Amendment, and now equal political rights, the 15th Amendment, voting. The amendment's text consisted of two crisp sentences. The first sentence declared, quote, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude," unquote. The 14th Amendment, Section 2, where the words right to vote first appear in the Constitution, had spoken of the right to vote in a much mushier way. The 15th Amendment concluded with language virtually identical to the concluding clauses of the 13th and 14th Amendments. The three Reconstruction Amendments were a package that came from the Reconstruction Congress and that all future Congresses could sweepingly enforce via appropriate legislation. So remember, Congress is going to have power now to pass voting rights. That's going to be the next panel. I'm trying to tell you, what the constitutional foundation is for this 60th anniversary that we're commemorating. Why, we might ask, did Abe's allies in 1869 to 70 succeed in doing what seemed politically impossible only 3 years earlier? First, Reconstruction Republicans in 1866 had to deal with an obstructionist president who, in reverse Lincoln fashion, was using all his tools and skills to thwart reform. Whereas Abe had pushed through the 13th Amendment, that's the Spielberg movie, Andrew pushed hard against Abe's congressional allies. Congressional Republicans eventually neutralized this war Democrat via impeachment in mid-1868. Chasten Johnson abated his obstructionist techniques in response to, indeed, in exchange for, a narrow Senate acquittal. By the spring of 1869, Abe's nominal running mate was out. And I wrote this years ago. It's now just being published. Okay. By the spring of 1869, Abe's nominal running mate, Johnson, was out, and his true heir, Grant, was in. Much as Abe had helped push through the 13th Amendment in 1864-65, so now Grant, first as president-elect and then as president, helped push through the 15th. Unlike Johnson, Grant viscerally shared the vision of Lincoln's last speech and its insistence that black Union veterans had earned in blood the right to vote. Lofty ideals aside, Grant had a personal political incentive to back the 15th. Although he had won the 1868 presidential election comfortably, his Democratic opponent, Horatio Seymour, had likely won more white votes. So he wins among blacks in the South, you see. A 15th Amendment guaranteeing the rights of black voters, not just in the South, but in the North, might be a boon for Grant in the next presidential cycle. Newly enfranchised Northern black voters and newly re-inspired Southern black voters would likely back the man who had backed them. Second, so one thing is you got the presidency on your side, you didn't before. Second, presidents matter. Second, Republicans in the 1869 Congress had far more time to push through an equal voting rights amendment. Back in 1866, the 14th Amendment had cleared Congress in June 1866, only months before the upcoming fall election. One key part of Abe's broad anti-slavery coalition, bigoted Northern whites, heirs of David Wilmot, might well have defected from the coalition had 1866 congressional Republicans backed full voting rights for blacks. And most Northern blacks couldn't yet vote. But in early 1869, lame-duck Republicans proposed the 15th Amendment nearly 2 years before the next congressional election in late 1870. They knew there was time enough to push and whip the amendment through friendly state legislatures before the next election day, when new black voters could at least partially offset, perhaps more than offset, any lost votes from Wilmot-style white bigots. Okay, so this is all about elections. There are certain dates. You've got to have deliverables by a certain date, and you can time it, assuming, of course, that we hold our elections properly on time. Third, and most important of all, in 1866, almost no blacks could vote in those parts of the country where most blacks lived, the former Confederacy. But by 1868, Southern states had enfranchised blacks in order to gain readmission to Congress. This is part of the history of Reconstruction. Thus, by early 1869, Congress, for the first time in history, teamed with lawmakers who owed their seats to large swaths of black voters. This is from the South. And who would soon have to face acres of black voters again. White voters in the North had first imposed black suffrage in the South, and now black voters in the South were imposing black suffrage in the North. Multitudes of black voters in America. This was virtually unprecedented and truly transformative. Once again, Harper's Weekly brilliantly dramatized the key developments, this time in a bold cover sketch by Alfred R. Woad, aptly entitled The First Vote. And if you flip it around, you'll see that. The balloting process depicted here is not a perfectly secret one. Although no slave would have been able to vote his free will in this open-air precinct, there's not secret ballot. So slaves, if you tried to let them vote, the master would just force the slave to vote the master's way. There's not secret ballot yet. But now that they're free, you don't have to worry about what the master thinks. Okay? Although no slave would have been able to vote his free will in this open-air precinct, with a white man closely observing the decisive moment of choice, forever free black men with free wills are now proudly participating on equal terms. Of course, black voters were now free to vote for black candidates. The very month that the 15th Amendment was ratified by the requisite number of states in good standing, and thus became part of the law of the land, the first black Congress member in history swore his oath of constitutional allegiance. His name was Hiram Revels, Mississippi's newest senator. Mississippi. Revels was the first black man, but not the last, to join Congress in this era, as illustrated by a handsome Currier and Ives print available for sale in 1872. That's the bottom graphic, featuring 6 black members of Congress alongside Senator Revels. South Carolina's Robert Carlos DeLarge, Robert Brown Elliott, and Joseph Hayne Rainey. They're from South Carolina. Georgia's Jefferson, note the name. Franklin, note the name, as in Jefferson and Franklin, you see. Long. Alabama's Benjamin Sterling Turner, and Florida's Josiah T. Walls. Meanwhile, Blacks were not just voting for state legislatures, but also voting in such bodies, having been elected in substantial numbers across most of the former Confederacy, the region where most blacks lived. In the decade after Appomattox, more than 1,500 black men sat in state upper and lower houses and or held other notable positions in state and local government. Mission accomplished. Or maybe not. Keeping all the civil and political rights guaranteed on paper by the 14th and 15th Amendments would prove impossible in the decades ahead. Many of the promises made in these amendments would not be fully redeemed until a century after Lincoln's death. So now I'm going to transition, you see, because here's what happened afterwards. Louisiana, for example, I'm going off the text here. Louisiana goes from 130,000 registered blacks in 1898 to less than 130,000 to less than 1,000 in 1910. Okay? No major civil rights laws are passed really between 1875 and 1963. There's a little blip in 1957. Okay. So we're about to hear now about how there's going to be a new generation, a new vice president turned president named Johnson, and another martyred president, not Abe, but Jack, and his assassination will move the country to redeem this vision that was promised, you see, in the Civil War, and briefly, for one brief shining moment, perhaps implemented. So that's what you're going to hear in just a minute. If I could, I apologize for this. This is going to sound very tacky, but I'm so honored that you invited me here. I only have a few minutes with you. I'm greedy. I want more. You're an amazing audience. So here's actually, if you found this interesting, here are two things you can do. One, I have a free weekly podcast. There are over 200 episodes, and if you listen, you can get CLE credit, and you'll learn a lot more, maybe, stuff about, where our rights come from, how we lost them at times, how we can get them back. It's got a kind of a cute name, America's Constitution. But you just Google Akhil Amar podcast. It's free, and you can get CLE credit. Second, I've written this book. I'd love for you to read it. I'd love for you to pre-order it, and here's why. Because if you pre-order it now, I'm going to be back here in Philadelphia on pub date, September 16th, at the National Constitution Center, and I can sign up a copy for you, which I would love to do. The Committee of 70, my friend Lauren Cristella, and other sponsors, you were very kind. You offered me a very generous honorarium to come, and I said, no, thank you. I'd like you to take all that money and buy books and give them to high school students, which Lauren is doing. So I'm very grateful in your name and on your behalf. So I'm not trying to truthfully make money off of you, but I do want you to read the book. Actually, I'd love you to pre-order the book because you need to know all of this, especially us leaders in the legal community before the next election. The only thing we Americans have in common, it's not race, it's not religion, it's not politics, it's not geography, it's not even first language, it's the Constitution and the story behind it, and you need to know that going forward so that we can return to that noble idea of we, the people of the United States over there, and that thought over there that all persons are created equal. Thank you very much.
Thank you, Professor Amar. We appreciate the foundation that you've laid for our next conversation. So I am very excited to welcome our panel to the stage to provide their thoughts about the Voting Rights Act, the past, the present, and the future. Ben Geffen, senior attorney at the Public Interest Law Center, will moderate and introduce the esteemed panelists. Thank you, Ben.
Thank you, Kathy. Thank you, Professor Amar. I really look forward to reading your book. appreciate those remarks. It's a tough act to follow, so we just won't follow for very long. So we don't want to get in the way of the reception and the rest of this day. But did just want to briefly note that we're, as Kathy mentioned earlier, going to put together a much more extensive version of this conversation in the form of a CLE program in August. And we will send out save the date information as soon as that's finalized. Let me just first introduce the panelists today. Marian Schneider is an experienced civil and voting rights advocate, lawyer, and litigator who has served as co-counsel in significant high-impact voting rights cases in Pennsylvania. Among her roles in the democracy space, Marian previously served as Deputy Secretary for Elections and Administration in the Pennsylvania Department of State, where her signature accomplishment was the launch of Pennsylvania's online voter registration application, among other pro-voter reforms. As Executive Director of Pennsylvania Voice, Salewa Ogunmefun guides a powerhouse network that expands democracy through top-tier voter registration, landmark census drives, and fair map wins. Her decades-plus work of organizing across 15 states and a signature victory on Philly's Fair Work Week fuels her mission to build lasting community power. I'd like to ask you first to talk just a little bit about something to follow up on Professor Amar's remarks. He spoke about the struggle for voting rights leading up to the passage of the 15th Amendment and beyond. But how did the Voting Rights Act of 1965 and subsequent amendments build upon or diverge from those earlier efforts, particularly in addressing systemic discrimination?
I just want to make sure it's on. Greetings all, and thank you for the lovely introduction, Ben. Before I jump into the question, I just want to give a disclaimer. I am grateful to be in a room of so many amazing attorneys. Shout out to the honorees from earlier today. But I am not an attorney. I am a political strategist, and I think about the work that we do as we have partners that are doing organizing, which builds power, legislation that sets the rules, litigation that enforces them, and the work that we do really brings all of that together. And so I was really grateful, Professor Amar, earlier you actually specifically mentioned Mississippi. And I actually want to use that as an example to talk about how powerful the 1965 Voter Registration Act really was. In 1964, the black turnout rate in Mississippi was 6%. In 1969, it was 59%. And so just want to say that and really have you all hear how powerful that was for the impact it had on people's lives and the ability to actually participate in the system. And I think that the biggest and strongest things that I want to point out that we got from the 1965 Voting Rights Act is prior to that, states were trusted to do the right thing, right? And you all know that's never how it works. Laws wouldn't exist if people could be trusted to just do the right thing. And so the 1965 Voter Registration Act really created an enforcement mechanism that through pre-clearance that required states to no longer just be trusted, but set a standard and required that the federal government was stepping in order to actually repair when states were doing things that were incorrect. And so that enforcement mechanism is so important. We can pass laws, but having something to do when people are violating them makes all the difference in what people's lives look like every day. I will also just point out that in terms of the 1965 Voting Rights Act, it also expanded the scope of what was actually protected to any mechanism. So it expanded it from race, and it included language. Language access was one of the really, really important things in a country where we have immigrants coming in every single day that should have the right to vote in the language that is the most comfortable for them. But then also created geographic protections as well. And one of the things that Ben mentioned earlier that my organization has worked on is redistricting. And so often we go to elections and we're casting a ballot for the people that are on the ballot, but redistricting really sets who gets to be on the ballot and who doesn't and who can win and who cannot win. And the 1965 Voting Rights Act created protections in order to make sure that communities of interest had the power to actually vote for people in elections that would represent their interests. So I think that's the biggest protections that I'll point out from the 1965 Voter Registration Act.
And Shalom, on your remarks about pre-clearance as part of the Voting Rights Act, wanted to talk a little bit about the Shelby Counter versus Holder decision from the U.S. Supreme Court and what the Marian, can you talk a little bit about what the practical impact of this ruling was on states that were previously covered by Section 5's pre-clearance requirement, and talk a little bit about what it meant for Pennsylvania in particular?
How about now? Oh, good. Thank you so much for all of you for being here, and I really appreciate the opportunity to talk about this. So today actually is the anniversary of the U.S. Supreme Court's decision in Shelby County versus Holder in 2013. And there were two mechanisms for enforcement under the original Voting Rights Act. Section 2, which prohibits any practice, procedure, as Salewa said, that abridges or denies the right to vote. And Section 5, which was a pre-clearance requirement. In Shelby County, Alabama didn't think that they should have to get their practices pre-cleared anymore. They brought this lawsuit a couple of years before 2013, saying, you know, times they have changed, and therefore we really don't need to be pre-cleared anymore. The 9 states and the counties that were established in 1965 should no longer have to have their practices pre-cleared. So what Shelby County case did was hold unconstitutional the criteria for states to be subject to the pre-clearance requirements in Section 5. Section 5 is still part of the Voting Rights Act today. However, no state, there's no criteria, so no state is subject to that requirement. So in order to understand what's happened in the 12 years since Shelby County, we have to understand what the court did. There could be pre-clearance requirements. Congress could correct or do what the Supreme Court said and establish relevant criteria, and in every congressional session since 2013, there has been a bill introduced. There's one pending in this session, the John Lewis Voting Rights, I always get the wrong, Restoration Act, or let me get that right. Voting Rights Advancement Act. It's changed its name in the various sessions of Congress. And that would establish nationwide standards for pre-clearance, but based on the practice, not on the history of discrimination that was the criteria previously in the Voting Rights Act. So in other words, there are certain practices that are demonstrated to either have an impact or be intentionally racially discriminatory, such as creating at-large districts in jurisdictions where there's a predominant minority population, such as restrictive voter ID, such as what North Carolina did, which is roll back all of their early voting, all of their making the provisions they had to make it easier to vote. So I'll stop there, and we can talk more at the CLE in August.
And hopefully we'll have a little time to talk about Pennsylvania then too. So Pennsylvania was never covered by the pre-clearance requirement, but there were knock-on effects from the Shelby County decision that we felt in Pennsylvania, and also we've managed to export some of the less positive voter practices that have been in Pennsylvania, a lot of other states, thanks to that as well. And I wondered if we could talk just a little bit more about some of the most common forms of voter suppression and dilution that we see in the 21st century that affect communities and in Pennsylvania and around the country, and how those tactics have evolved.
Of course we can. So again, I like to start with data, facts, and just ground us in like the reality of the experience in people's lives. And so 1965, Voting Rights Act, right? In 1966, 85% of white people said the pace of civil rights was going too fast. 1965 Voting Rights Act, 1966, 85% of white people said the pace of civil rights was going too fast. And so what does that mean? And Marian previewed a little bit of what that means today and the things that people have put in place to try to roll back the 1965 Voting Rights Act. And I really love the framing of the question, Ben, because the reality is that we haven't just seen a return to voter suppression. We're currently living in its evolution. It is more surgical, it is more data-driven, and it is often masked in neutral language that masks deep intent. That looks like voter ID laws, that looks like voter roll purges, that looks like polling place closures and relocations, that looks like voter dilution. I talked about redistricting for a moment earlier, packing and cracking that makes it so when you get to the ballot, you never have an opportunity to actually elect someone that you believe you have the opportunity to elect because they took that away from you 10 years before you ever got to the ballot. And in that evolution, today's voter suppression is powered by voter data, predictive modeling, and legal pretext, right? So like, let's talk about Pennsylvania for a moment there, and I would love Marian to actually just highlight some of the work that I know you were a part of in the voter ID fight right here in Pennsylvania. Voter ID was passed in Pennsylvania in 2012. It was ruled unconstitutional because it was going to be so discriminatory that the General Assembly wasn't allowed to pass it into law. Did it go away? No. We've just seen it evolve in the form that people are looking to pass voter registration in Pennsylvania. So instead of passing it through law that can be vetoed by a governor or can be overruled by the Pennsylvania Supreme Court, we're now seeing voter ID being looked to pass as a constitutional amendment, which would change whether it's vetoable, which would change whether or not it can be taken back later in the future. And so when we're talking about voter suppression, we're talking about it right here in Pennsylvania. Before we even implement voter ID, there's a journal out of New York, the Election Law Journal, that every 2 to 3 years publishes a list of like states that make it the most difficult to vote. The list of 50 states. Pennsylvania is 31st. We are 19th from the bottom. It is more difficult to vote in Pennsylvania than it is in Florida. I just want to leave you all with that.
Well, I think that one thing that you have to understand is that after the Shelby County decision, I mean, within seconds, states that were previously subject to pre-clearance passed restrictive laws throughout in their states, and these laws they weren't subject to pre-clearance, and so they were passed and are in effect. But the thing is, what is important to understand for the impact in Pennsylvania is that those who would suppress the vote play from a national playbook. The law that Shalom mentioned, Act 18 of 2012, which was a restrictive voter ID bill, was lifted from the national playbook. It was not tailored to what Pennsylvanians need, it had nothing to do with Pennsylvania. And just so you know, and on Public Interest Law Center's website, you can see our expert reports from the trial in 2013. More than 380,000 voters lacked a Pennsylvania driver's license. And of those, but I don't remember the numbers, it was like in the 400,000, I think, but 180,000 of those voters voted in the 2012 presidential election. And the margin of victory in presidential elections has not been nearly 180,000 voters. So keep that in mind when you think about what the impact of restrictive voting rules has on voters. And that law was targeted to Philadelphia, just saying.
I should add, when we did that litigation, the state did dispute those numbers and said, that's only 87,000 people who aren't going to get to vote under this new law. You guys are exaggerating. Lastly, and we have just a couple minutes left, so let's move through this quickly, but can you talk both just a little about, from a legal and an advocacy perspective, what do you see as the most critical steps, legislation or litigation, that need to be taken to ensure robust and equitable access to the ballot box for all Americans?
Okay, I'll go first. For the U.S. Supreme Court and the appellate courts have further eroded the Voting Rights Act since 2013, reducing the ability to file a private right of action. The Eighth Circuit has 2 decisions on that. Also, there's in the Brinovich case, the U.S. Supreme Court has made it more difficult to bring a Section 2 cause of action. So what we have done in Pennsylvania is look to the state constitution, Pennsylvania state constitution, which has a strong textual guarantee of the right to vote called the Free and Equal Clause, and that says elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. It was under that provision, and only under state law, that we brought the Applewhite case on voter ID in 2012 and 2013. And in fact, the Baxter case is pending in our Supreme Court right now, which asserts that the meaningless handwritten date requirement on mail ballots violates the Free and Equal Clause. That's fully briefed. We don't have a decision. But we need other mechanisms to turn to, because the federal Congress is not going to act. The federal courts are eroding the Voting Rights Act, The standard for testing the constitutionality of statutes is more lenient in the federal system. In Pennsylvania, we argue, and we have been successful in arguing, that strict scrutiny applies to the free and equal clause. So that's the way to proceed, where you have a state Supreme Court that respects the rule of law. And I'll just say, oh yeah, there are retention elections this year.
That was beautiful. So I'll say the brilliance of the VRA is that it looked at not just what laws were passed, but where they passed, who they impacted, and why. And so I think that we need to go back to look at that lens again. And so there's 4 different ways I would encourage us to do so. The first is we have to make voting rights cool again. Sometimes the way we talk about it leaves people out. When we say voter suppression, honestly, above everyone's head, no one cares anymore. So we need to talk about it in a lens that the general public can actually understand and see themselves in it. Something's making it easier to vote, or it's making it more difficult to vote, and that's it. We need to rebuild the federal floor, right? Marian already talked about the John Lewis Voting Rights Advancement Act. We need to see that passed in Congress. We need to pass a state Voting Rights Act in Pennsylvania. That is the protection that we have when the federal government is going off the rails, as it currently is in a lot of different ways. And so let's ramp up the protections in state and make sure that we have those things mirrored in ways that we can actually enforce. And the last thing, and I think Ben talked about this earlier, like we need to litigate with the system's lens. There are things we can do. State constitution in Pennsylvania has robust equal protection clauses and free election clauses. 28 gerrymandering cases, another great example of that. We need to target vote dilution, and we need to defend the infrastructure. In Pennsylvania, there are 27 counties with 27 different rules of how you vote. That seems kind of confusing. Let's do something about it.
Thank you both. Thank you, Marian. Thank you, Salewa. And let me also just remind everybody, September 16th, Professor Amar's book is out. Please get your copy. Thank you. Okay. Do we have time for a question? Somebody has a question.
How about we take 1 or 2 minutes, because we are actually on time, which I am so proud of the panelists for. We'll take at least one question. Go ahead.
Yes, please.
My name is Abe Rich. I've had the privilege of practicing in Philadelphia for over 50 years, but I profess no expertise in voting rights or the depths of the Constitution knowledge that has been demonstrated in the last hour. I want to thank the professor and the 2 panelists for really an excellent overview insight. With the brilliant minds, including the professor that we have in the room, I have been shocked by an article that was in the New York Times in the last week about a law student, second-year law student at the University of Florida, a professed white nationalist, a professed anti-Semite, who was in a course writing a paper, and he was given the best paper award by a federal judge and another distinguished professor, who made the argument that we the people, which the professor alluded to, did not include white people, and he referred to certain only included white people, excuse me, thank you, and the amendments, and therefore people of color were not entitled to any rights, including voting rights. I found that so shocking that I need some, professor, someone in your class wrote that paper. How do you handle that, to give credence to it, to be able to say it's the best paper in a respectable law school? I'm sorry for, it's just, I didn't have an audience to raise this. Thank you. Sure. Professor? 8 for you.
To try to stay on time, I actually cut out a couple passages of my talk. Can you hear me?
Yep.
Yeah. Okay, so here's where that's coming from.
Professor, would you stand?
Okay, yeah. Where that's coming from, in part, honestly, is an argument that the 14th and the 15th Amendments were not validly adopted because the South had to say yes with a gun to its head. And they weren't going to be let back into the former seceded states. We're going to be let back into the House of Representatives and the Senate Electoral College unless they did two things. They ratified the 14th Amendment, and then later the 15th, and that lacks a vote as a condition for readmission. And I said, by 1868, Southern states had enfranchised blacks in order to gain readmission to Congress. I pulled out a sentence because I wanted to stay on time. So this was a fair demand on Congress's part. Regimes disfranchising huge chunks of adult, free, male resident citizens were not truly Republican governments per the Constitution's Article 4. Now, if you want more on that, that's a sentence. This is embarrassing, and these are, you can get them in the library, but I devoted major chunks of a book in 2000.
Pre-order.
No, these are books that are way out there. In 2005, called America's Constitutional Biography, where I spent about 10 pages explaining why the ratification of the 14th and 15th Amendments, though somewhat unusual given that it was in the wake of a civil war, were perfectly valid. And I come back to that because I saw this day coming and I wanted a rock-solid foundation of all this. So it's called America's Constitutional Biography, 2005 is Chapter 10, and America's Unwritten Constitution, Chapter 2. Okay, where I talk about all this. I want to say one other thing, because what scholars do matters sometimes. That decision, one of the 3 worst in my lifetime, Shelby County, and I didn't realize today was the anniversary. There's an epic dissent by RBG. And I'm ridiculously proud of the fact that a key part of that dissent that is the most important paragraph in the dissent. She said the majority just completely forgetting the history of Reconstruction, which was designed to be transformative. And she cites 2 people, and one is yours truly, and one is a conservative judge named Michael McConnell. If you don't know your history and you don't stand on it, we're going to lose things that people died for, okay? And so I actually am an originalist because actually I believe in all men are created equal, and I believe in we the people, and I believe in Lincoln and the Gettysburg Address, who was an originalist. When he's saying, let's do those things, Gandhi was once famously asked what he thought of Western civilization. He paused and he said, I think it would be a good thing. There's so many good things that are actually in the Constitution. Let's do those things. But you, especially the lawyers, need to know what really was in it, how it was done, how it was lost, because it was lost, and some of it, oh, you were spectacular. But it's being lost again. It's being lost again. But you need to know, and there's a playbook, there is, and you need to know how it was won, and how it was lost, and how we have to win it back again. Thank you.
So grateful for this incredible panel, for the wonderful Professor Amar, for the question, for Lou Ruley for the idea. And as you can see, the fragility of what we have from the past and where we are today based on the question. Where are my tissues? Okay. But I have hope. And where's my hope from? Every one of you in this room. Because you're here, you're hearing this incredible conversation, and you are in positions to preserve, to keep safe the rights from our history. So long as you know it, you learn it, and you press forward. Thank you so much to the wonderful panel and Professor Amar. Woo, okay, more to come in the August CLE. Okay, we have some incredible important business to do, and I say business because it is part of our past and our future, but really primarily our past, and I do have my tissues. I didn't think I would start so quickly. Tonight's quarterly is the last quarterly of our one and only Harvey Hurdle as our Executive Director. Woo! I'm already starting. You know, it's fitting that the topic of this evening is voting rights. because our association's efforts in the area through our Judicial Commission have been particularly meaningful to Harvey, as he has worked tirelessly to increase the influence of the commission. But this is really just the tip of the iceberg, because we are here tonight to honor Harvey and the work that he has done in the past 6.5 years on behalf of this association. Working side by side with our wonderful staff and volunteer leadership, Harvey has led the organization to a budget surplus, spearheaded a rebranding website redesign, stewarded us through a strategic planning process. He launched our institutional membership program and relaunched our annual partner program. He has brought dynamic leadership to our organization, encouraging us to innovate and to grow to fit the needs of today's legal professionals. He has always worked to put the member experience first and foremost, adding on-demand CLE platform, complimentary legal research, and expanding our annual Membership Appreciation Week to honor the outstanding individual contributions as association bar stars. Under Harvey's leadership, the Judicial Commission and Campaign for Qualified Judges have had 4 election cycles where only judges rated highly recommended and recommended by the commission have won seats to the Philadelphia Court of Common Pleas. This is a tremendous accomplishment. Harvey has brought tremendous value to our association through his leadership, working with our Board of Governors to advocate on behalf of the profession in support of the rule of law and equal access to justice. He leaves the association on June 30th as Executive Director in a stronger position than it was in furtherance of its mission for decades to come. Okay, as part of our remarks tonight about Harvey, I have a little surprise. I thought it was important to let him know the tremendous impact he has made to our organization. So we have special guests here to share what Harvey's work has meant to them, and it is our leadership of the association. So I'm going to actually start with Christine Callalang, our Vice Chancellor, who unfortunately was unable to be here with us tonight, but here are her thoughts. So imagine Christine is speaking. Harvey is a very special person. He is warm, he is welcoming, and graciously invests his time and energy in building and supporting leadership in our wonderful association. Christine fondly remembers Harvey, encouraging her to run for the Board of Governors, and the rest is history. All her love to Harvey on his retirement, and she looks forward to staying connected in this new, exciting chapter of his life. Ezra Wergerlernter, our Chancellor-elect.
Before I decided to run for Chancellor, former Chancellor Abe Rich told me there's one person you need to talk to, Harvey Hurdle. And we met at some clandestine place. And he really encouraged me to run. He understood the challenge I had in running for the election, embraced the idea of a contested election, and here you are. I'm the Chancellor-elect, and I owe a lot to Harvey, not just for encouraging me to run for election, but the support and encouragement he's given to me as a rising leader in this association. I want to say just a word or two about our Chancellor, and that is that as Philadelphia lawyers, we represent the conscience of our community and our profession. And we as an association have not just spoken about the defense of the rule of law, but we have acted to protect the rule of law. As threats to our independence have arisen, we stood united defending the legal profession against any effort to intimidate lawyers or silence law firms. We must and will remain vigilant in defending the rule of law, and I ask you to acknowledge our Chancellor for her leadership.
of it without Harvey by my side. Jen Coatsworth, our 2024 Chancellor.
Harvey has been a transformative leader for our association. He brought with him decades of connections within the city that has helped amplify the association's prominence and prestige. At the same time, he streamlined internally, and he helped us develop a strategic plan that puts us in a great trajectory moving forward, among countless other achievements. We are truly grateful for all he has done. Harvey has been an exceptional executive director, but even more, he has been a truly valued and honored friend. I'm going to miss you terribly.
Mark Zucker, our 2023 Chancellor.
Thank you. Kathy has already so well described your contribution to the Judicial Commission, for which we will be eternally grateful. I just want to focus on your sense of fiscal responsibility and the common sense that you brought to this position, without which we really could not have succeeded. Without that, we would have probably overspent and ran through our reserves. We found new sources of revenue, and you continued our trend so ably led by CFO Susan Knight to reduce expenses. Likewise, you expanded our efforts, so ably led by Andrea Morris Tracy, to increase membership with institutional partners, standing side by side with me to make that happen. And that added depth to our association. You supported the initiatives we introduced, and as a result, we are well positioned to move forward. Thank you so much, Harvey.
Wes Payne, our 2022 Chancellor.
Harvey, what I have to say to you isn't along the lines of all the great things that you do, because what you really do and what makes you really great is that you supported every chancellor, no matter how different we were and how different our objectives were. And I always remembered during the year, the first call you get every morning is from Harvey Hurdle. Tell you what's going on so you don't get surprised by anything. You know what's going on. Hey, I'm going to tell you right now, the Philadelphia Bar Association knew what was going on in the state before the Pennsylvania Bar Association was going on in the state, and that was because of Harvey Hurdle. And my wife and I used to make a little comment. We called it breakfast or coffee with Harvey. Colonel, congratulations, you have earned your retirement.
Lauren McKenna, our 2021 Chancellor, cannot be here tonight. She is so sorry for that, but here are her words. Hopefully you get the themes. These are all of the Chancellors who had the privilege of getting to work with Harvey. This is Lauren. I began my tenure as Chancellor in 2021 amidst the COVID-19 pandemic, and Harvey Hurdle was right there with me, a true partner. Harvey was a steady hand in turbulent times, helping me plan official statements, guide the Bar Association through court reopenings and remote work debates, and decide when and how to resume in-person events. Over that challenging year, we became friends in shared objectives of the association and true friends. I wish him the very best as he embarks on his next chapter, focused on family and travel. Mike Schneider, our 2020 Chancellor.
First of all, I want to thank Kathy for giving each of us this amazing gift, this amazing chance to say what we really feel. Harvey and I began working together before he became Chancellor, and we quickly established a routine, and that was the 8 a.m. telephone calls. Now, I was very glad, by the way, that these calls were not always on video, because many times Harvey was getting me right as I was coming out of the shower. Probably more than he ever wanted to see. So, in any case, though, from the very first minute when I met Harvey, I was impressed with his enthusiasm and his excitement about meeting the challenges of running our association. Over the years he has been with us, Harvey has been a steadying force, a voice of reason, an innovator, and most importantly, a trusted friend and colleague. I have missed our 8 a.m. calls. We still talk, but not at 8 a.m. I understand that part of Harvey's plans for the future are some travels. And as I close, I want to bring forth some of the words from a very, very old Irish blessing. And that is, as you go forward, may the road always rise up to greet you. May there always be a wind blowing at your back. May you have safe travels, my friend.
Last but never least, Shelley Fadullo, our 2021 Chancellor.
Hey, Harvey. Harvey and I have a running joke. I was his first. So he started it, so I'm going to end up. Harvey, I'm going to give you a number. 2,368. I guarantee you I know what it is. That's how many days you've been executive director. Oh, I must not have enough to do because I actually figured that out today on Google. So I'm going to ask you to relax. I'm going to thank him 2,368 times. You all are fine with that, right? That's what you would say. I was on the search committee. Abe was in the search committee. Mike was in the search committee. I think that was all of it. I can remember seeing your resume and saying, "Oh my God, this guy's amazing." And when you got up there, man, you had me at hello. He was so authentic, enthusiastic. He was just amazing. And nothing has changed. You know, when this is like your anniversary, this is like your 2,368th anniversary, whatever this number is. And you know, when you think about anniversaries, you'll say to your spouse, "Would you have done it all over again?" Absolutely. Every day has been wonderful. I'm so proud of you. I'm so grateful for you. I thank you for the partnership. You haven't been able to get rid of me because you always drive me places. I'll get a new ride to Bench Bar, I guess. But Harvey, everything about you has been wonderful. What you've done for this association. And I incorporate by reference, which is one of my favorite terms. I incorporate by reference everything all my colleagues said, what Kathy said, all of which are beautiful. But in addition to being a wonderful, exceptional leader, you are an amazing man. Thank you so much.
Harvey, I'm sure each of the words of the leaders you've worked with over the past 6.5 years have been meaningful to you. Whew. For me, what can I say? I liked it better when I was mad at Harvey saying that he was retiring, because here it goes. I want to thank you, first and foremost, for your humanity, your kindness, your generosity of spirit, your generosity of time, and your generosity of love. Please know none of these have gone unnoticed and nor unappreciated. I have been the recipient of all of these things, which are part of your true nature. It's your DNA to be kind, caring, and generous. And so for me, while your leadership, your advancement of the association goes without saying, I am grateful for and will always be grateful for your role as a conciliary with all of the humanity that comes with it. It's who you are at your core, and for that we are grateful. Please join me in welcoming Harvey Hurdle to the podium. Sorry.
Thank you.
Do you have your speech? It wasn't here. Do you have it?
I have another copy. Whoa. That was wonderful and uncomfortable. Thank everyone for their incredibly kind words. They mean so much to me. I want to start by congratulating our Cheryl Ingram Award winners, Megan Watson, Victoria Sorosis, did I get that right? Sorois, I'm sorry, and Asylum Pride House. Thanks for all you've done for the community, and as they said, happy Pride to everyone. One of the most important things I can do today, and I'm going to repeat some of Ezra's words, is acknowledge our 98th Chancellor. I know that serving during an executive director transition at a time when the rule of law is under assault and the basic ability of attorneys to practice without fear of retribution is in question. It's not the year you planned for or expected. But we're so lucky to have you. I know you're just the right person to lead us, association, and show us all how to meet the moment. Thank you, Kathy. Serving as Executive Director of the oldest and best bar association in America for the past 6.5 years has been the honor of my lifetime and a full circle moment. Many of you may not know I grew up wanting to be a lawyer, but as a very closeted gay senior at Penn State, I decided not to take the LSAT. I dreamed of being a politician, and I could see no future for a gay man in politics. The time was pre-Ellen, pre-Barney Frank. The only politician I knew that was gay was Harvey Milk, who had been assassinated tragically 4 years earlier. So you can understand what it means to me to be able to lead this wonderful association of lawyers. I am so indebted to the legal community. I know that the fact that I stand here as a gay man with my husband and son sitting in the front row is because of the work of incredibly smart lawyers, some who are members of this association, and very courageous judges. Thank you all. I'm proud of the accomplishments of my association during my tenure, and you're not going to hear any more of them. We're going to skip that section. There's one that didn't get mentioned that I'm also very proud of, was that we are part of a coalition that helped deliver right to counsel to low-income tenants. And we want to reemphasize that we are proudly and courageously standing up for the rule of law by speaking out, filing amici briefs in support of law firms, and standing at one at City Hall to reaffirm our commitment. That was one of the proudest days of my life. I must admit I've enjoyed the recent celebrations of my time at the bar, but I need to correct the narratives. These accomplishments were not Harvey's accomplishments. They were our accomplishments. So many thanks are due. First, to the chancellors who were here, who spoke earlier, thank you for your leadership, partnership, and most importantly, your friendship. I have seen firsthand your dedication and how much you love this organization. So thank you. To our volunteer leadership who have served on the Board of Governors or as section and committee chairs, you are the lifeblood of this organization. You have served in these roles in the past 7 years. Would you please stand? Here we go. The people most responsible for our success is my amazing team at the association. Your talent and tireless dedication to the association to make everything possible. My wish is that you felt as supported by me as I felt supported by you. Will you please stand if you're not already standing in the back? Thank you. A special shout out to Susan, Wes, Tara, Andrea, Michael, Diana, Jill, Flo, Janice, and Yvonne, who are all with me since day one. I want to acknowledge a couple past employees in the audience as well. Didn't get a chance to stand. Andrew over there, Councilmember Landau, and especially Charlie Klitsch, who is who's still on my speed dial. So thank you. I've been asked by many of you, why are you retiring now? And the answer is sitting in the front row. I am so proud to be joined by my family, my big sister Kathy, and her husband Joe, my little sister Patty, and her partner Natalie, my nephew Jason and his wife Stephanie, their children, my great niece and nephew Lily and Jack. Thank you guys for being here. Like my amazing husband of 37 years, Kevin, to stand. So, please. Some of you may have heard me joke that he should qualify for staff benefits because he had to listen to all those COVID calls. Mom, would you please stand? This is my mother, Kathleen. She is the glue that holds this family together, and I can't wait to spend more time with you. Okay. And finally, my son, Evan, we are so proud of you. Your dads are looking forward to our upcoming trips to Scandinavia and Japan. But Evan, you know I don't let a day go by that I don't offer some advice. So here it goes. Although you've been very clear that you do not want a job as stressful as mine, and I get it, I have one bit of advice. Find a job that you love as much as I love it. Thank you.
Harvey, come on back up here. Thank you, Harvey, for your leadership, your friendship, your tireless work on behalf of our association. I would like to now welcome Council Member Rue Landau to the podium, please. As Rue makes her way to the podium, a huge shout out to Kevin Levy, a member of our Board of Governors who worked tirelessly with me to spearhead through a citation by the City of Philadelphia. And it's thanks to the office of Council Member Rue Landau. Rue, please.
Thank you. Thank you, everybody. This has been such an incredible celebration of your work, Harvey, your life, your work. You brought together everybody who loves you so much, both in your professional career, your family, and so many of us who are so lucky to call you friend. So I want to present to you something that was apparently was supposed to be a surprise, and I screwed it up. But it's a surprise for all of you. This is a resolution that I introduced for you in City Council on June 12th. It was voted on unanimously by all City Council members. It memorializes all of your incredible accomplishments, from your nonprofit leadership to your dedication and your work in the LGBTQ plus community, and also your incredible transformational work at the Bar Association. Congratulations. We love you. You have taught us all so much. We promise to take the torch and keep on moving with it. And while I don't want your 8 a.m. phone calls, I promise that we will be talking weekly. I love you.
Sorry. Thank you to the audience. All right, folks, what a night. Thank you so much. I know we're keeping you from the reception, so I actually want to close out with one exciting announcement that you've already heard about. We are proud to formally introduce our next Executive Director of our association, who's already begun work for a couple of weeks, working hand in hand with Harvey Hurdle. Christy Jones, please wave. Woo! Christy most recently was the Executive Director of the International Association of Women Judges. She is credited with growing membership by 81%. Christy, thank you for joining our family. Thank you to our speakers, our program partner, the Committee of 70, and of course the best staff in the City of Philadelphia, heck, the Commonwealth, the staff of the Philadelphia Bar Association. A special shout out to Allie, Rachel, Wes. Thank you all. Thanks for joining us. Please enjoy. I think the heat broke a little bit, so please enjoy food and drink. Thank you all so much.